On behalf of people. Your Honor, Sam Bernstein with and on behalf of Mr. Murray.
What you are about to watch is not simply a routine courtroom hearing. These early proceedings are where the direction of a criminal case often begins to take shape long before any jury ever hears evidence. Attorneys are already positioning their arguments, judges are evaluating credibility, and procedural decisions made here can determine whether a case advances toward trial or collapses under legal scrutiny. Right away, we hear discussion of a preliminary examination. In felony cases, this hearing is extremely important. The prosecution must demonstrate probable cause that a crime occurred and that the defendant likely committed it. It is not a full trial, but it is the legal checkpoint that determines whether a case proceeds to a higher court. Something else immediately raises the stakes in this opening exchange: the reference to a homicide charge. When a homicide is involved, every step of the process becomes more deliberate. Witnesses must be carefully coordinated, evidence must be thoroughly prepared, and even scheduling decisions can become strategic. From the outside, these discussions about dates and witnesses might sound routine, but behind that calm legal language sits an extremely serious accusation and a defendant whose future may depend on what happens during these early hearings. And as we continue through this courtroom session, you'll notice something important. The atmosphere can shift very quickly, from procedural scheduling to heated arguments about bond violations, criminal history, and whether defendants should remain free or return to custody. So pay close attention, because the real courtroom drama often begins long before a trial ever starts.
Your Honor, we're going to be setting this for exam. We've discussed scheduling, and we're hoping for the April 2nd date.
Is she being held on anything else?
Just this, Your Honor.
Is discovery complete?
To my knowledge, yes, Your Honor.
It is.
Yes, Your Honor.
People have their witnesses available. You're not available the 26th?
I am available.
This case has been on for a while. She's being held on a homicide charge, a felony murder charge.
All right.
There's a number of witnesses, including Detective Saints, who's retired. So we're hoping for the second date and hopes that we can get it done on that date.
Preliminary examination will be set in person April 2nd, 2024, 9 a.m. before. Before me. Continue. Thank you. Court calls case People versus Mario Cato.
Good morning, Your Honor. May it please the Son of Jermaine Mark, P54352, on behalf of Mr. Cato, who stands to my immediate right.
Your name?
Mario Cato.
I was just retained on this matter. From what I understand, we have to file a substitution and get discovery.
That is correct. We also have a problem with a bond violation.
This is where the situation begins to shift from routine scheduling to something more serious. The defense attorney reveals two critical issues. He has just been retained on the case, and there is already a bond violation problem. When a new attorney enters a case mid-process, they must quickly obtain the discovery materials. Discovery includes police reports, witness statements, video evidence, forensic reports, and other documents that both sides must exchange before trial. But the bigger concern here is the bond violation. When a defendant is released before trial, the court usually sets conditions. These conditions might include drug testing, reporting to supervision officers, avoiding certain locations, or maintaining contact with the court. If those rules are violated, even unintentionally, the judge may reconsider the defendant's freedom. From the judge's perspective, bond is based on trust. The court is essentially saying, you may remain free while your case proceeds, but you must follow these rules. If those rules are ignored, the court must decide whether the defendant can still be trusted to remain out of custody. So the hearing now moves from scheduling into something much more consequential, determining whether the defendant's freedom should continue.
I haven't seen anything in writing.
Can you hand that to him? It's not much. He hasn't gone. Around.
So we got to make sure you get it.
I wasn't aware.
Okay. Okay. I'll facilitate and make sure that he does this, Your Honor.
Well, why didn't he go?
He said he wasn't aware, Your Honor.
From the time of his arraignment, he was put on standard supervision and hasn't gone over?
No, Your Honor, I'll make sure that he does today. I'll walk him there myself.
We can provide the transportation if he doesn't know how to do it.
I'll be more than willing to help him. He's a law-abiding citizen, Your Honor. This is his first contact with the criminal justice system.
The defense attorney now shifts into a classic legal strategy, humanizing the defendant. By emphasizing that this is the defendant's first interaction with the criminal justice system, the attorney is attempting to frame the violation as a misunderstanding rather than deliberate misconduct. Judges frequently encounter defendants who claim confusion about court conditions. Sometimes that confusion is genuine. Other times, courts view it as an excuse. But defense attorneys know that framing matters. If the judge believes the defendant intentionally ignored the rules, the consequences could be severe, including bond revocation and immediate jail time. If the judge believes the violation was the result of confusion, the court may instead impose stricter supervision while allowing the defendant to remain free. You'll also notice the attorney offering to personally help the defendant get to community corrections and complete the required testing. That offer serves a purpose. It signals cooperation and responsibility to the court. In many hearings, attorneys must quickly demonstrate that their client is willing to comply going forward, but whether the judge accepts that explanation is another matter entirely.
Your Honor, the request from people, if the court would entertain, would be that they ego test right now, to get those results and come back and determine what to do with bond violations.
He's willing to do that, Julie.
You're gonna come back clean?
Yeah, I haven't smoked. So,
You come back with,
Can we, I just have 1 second, Your Honor.
yep.
For transparency, Your Honor, he said the last time he actually used was the date of the arrest. Other than that, he's been,
When the date of the arrest,
yeah.
which is what date?
partially.
The beginning of March, Your Honor.
To do it. Lady said,
You were supposed to do.
If I send you over for an ETG, you had anything to drink recently?
no. No, Your Honor.
The third.
Yes. March 3rd.
Pardon? So when at the beginning of March were you using?
I do not remember the exact date. I suffer from TBI, so my memory isn't the greatest, and I don't have anything right on me right now to go back and look on. But it was it was at the beginning. It's like 2 or 3 weeks ago, more or less. And when I got out of jail, they said that I thought I was supposed to drug test today. I didn't know I was supposed to drug test before. Your Honor,
So you knew you were supposed to drug test?
I thought that's what I was supposed to do today.
He thought today was supposed to be the first test, Your Honor.
Take him over to community corrections, get a test on him, let him know he's coming over, and then come back and we'll decide what I'm gonna do with this bond violation.
Okay.
Judge Simpson makes an interesting decision here. Instead of immediately ruling on the bond violation, he orders the defendant to take a drug test immediately and return to court afterward. This approach shows a preference for evidence over speculation. Rather than debating whether the defendant has been using drugs or violating supervision conditions, the judge wants objective verification. Drug tests used by courts typically screen for a wide range of substances including marijuana, cocaine, methamphetamine, opioids, and alcohol metabolites. If the defendant fails the test, the judge would likely view that as confirmation of non-compliance. If the defendant passes, it strengthens the defense argument that the violation may have been procedural rather than behavioral. This moment also puts pressure on the defendant. A test taken immediately in the middle of a hearing leaves no time for preparation or excuses. It's essentially the judge saying, "Let's find out right now." And moments like this can dramatically change the direction of a hearing.
Well, you went over, took a test, and surprise. I don't know what you are smoking, but it's no good. It's all negative.
Yes, around people are also in receipt of that test showing the defendant is currently negative for all drugs, including marijuana. The good baseline, so if it's positive later, we'll know that that was post for Raymond use.
Yes, okay. So counsel, you wanted an adjournment.
Yes, Your Honor, or
What date did you,
a couple weeks out would be great.
couple, 28th work for you?
I'm actually out of town that week, and then the next week I start a trial downtown.
Sounds like 4.
Well, you start the trial on the 4th.
On April 1st.
Okay, you show you that week. So April 11th, will that work?
That should be fine, Your Honor.
Probable cause conference, April 11th, 2024, 9 a.m. Defendant's bond will continue. I'm signing a new order regarding your testing, and I'm placing you back on standard supervision with urine testing once per week.
Judge Simpson chooses a middle ground. The defendant's bond will continue, but supervision will become stricter. Weekly drug testing is now required, which significantly increases monitoring. That means the defendant must regularly report and demonstrate compliance moving forward. This is often called graduated supervision. Instead of immediately sending a defendant back to jail, the court increases oversight and gives the individual another opportunity to follow the rules. But there's an important warning embedded in this decision. By requiring the defendant to sign the supervision order directly in court, the judge eliminates any future claim that the rules were unclear. From this point forward, any violation would be extremely difficult to explain. So while the defendant avoids jail today, the margin for error has become much smaller.
You understand?
Yes.
You understand?
And I'm going to have you, so that we're all clear, I need you to sign off on this order, young man.
I did in there.
No, I crumbled it because it was. Did they do it? Did they just test you, young man, or did they do an intake on you when you went over?
He has an intake form we're actually going to take back now.
Good.
Okay. You know the form that you were filling out. This is the third month. Got some problems. 3/14, 24.
All righty. Bond will continue with that condition. Thank you. Thank you, counsel.
Thank you.
Morning, Your Honor. Edward Lucas on behalf of Robert Bigham.
Your name?
Robert Bigham. Your Honor, today's time and date set for probable cause conference. I was appointed 2 days ago. I did get the discovery yesterday, and a lot of videos came in yesterday. I have not had the opportunity to review those with him. I'm asking for a 2-week adjournment.
Any objection?
The adjournment that I would like to address bond.
Probable cause conference will be adjourned to March 28, 2024, 9 a.m. as to bond.
We're requesting either revocation of bond or to renew our request for 100,000 cash surety in this case. The revocation request is we have received a community corrections violation. The defendant has never appeared at community corrections and has failed to ask for anything. So on that note, I'm requesting revocation of the bond and an immediate remand. However, in addition, at the time of charging this case, and before I go on, do you have the community corrections?
I do not.
I received it yesterday, Your Honor.
I sent it to defense counsel and I can forward it to.
Ann.
Provide you my copy.
Go ahead, Ms. Hughes.
At the time of charging this case, my office requested a 100,000 cash surety bond. The defendant does have an extensive criminal history in the sense that he has been convicted starting as far back as 2000. He was convicted of misdemeanor drug possession. In 2003, he was convicted of domestic violence. 2004, he was convicted of fleeing third. That's noteworthy here because this is a fleeing third case as well.
Now the prosecution begins presenting the defendant's criminal record, and it is substantial. Starting in 2000 with drug possession, the record includes domestic violence, fleeing police, resisting arrest, and even carjacking convictions. When prosecutors present a history like this, they are establishing a pattern of behavior. They want the judge to see the defendant not as someone who made a single mistake, but as someone with a long record of criminal activity. And prosecutors know that prior convictions, especially similar ones, carry weight when courts evaluate bond decisions. The prosecution then describes the current incident: a high-risk police pursuit involving erratic driving, traveling into oncoming traffic, and fleeing both in a vehicle and on foot. From the prosecutor's perspective, while this demonstrates that the defendant poses a danger to the community, the argument they are building is clear. Someone with this history and this type of alleged behavior should not be easily released. But the defense will soon attempt to counter that narrative, and the judge must decide which story carries more credibility.
In 2008, he was charged with but not convicted of domestic violence, third offense. In 2011, he was found guilty of resisting and obstructing the police, of a life offense of carjacking, and another carjacking and an attempted. That is his most recent, those are his most recent felony convictions from 2011. From that case, he was sentenced to 2 years to 5 years in the Department of Corrections. This is a fleeing and firearm case now, and his guidelines on this case are 14 to 28 months without a habitual, case. But at the very minimum, it doubles the 28 snap that I believe is 59. That's correct. In this case, the defendant was driving erratically, so erratically to the point that he at one point was driving on the opposite side of the road into oncoming traffic in an attempt to evade the police. His speeds were, as far as I can see from the report, as high as 50 miles per hour in a 35 mile per hour zone. He put not only the police in danger, but also the community. Then, in addition to that, as you can see from the other charges, after the police, so at some point the police did have to terminate the word. Thank you. Chase pursuit. Thank you. Team effort. Because of how dangerous it was, instead they continued to follow him at a safe distance. Once he stopped the car, he got out of the car and continued to flee from the police on foot. While the police actually yelled at him, he was going to be shot. They were going to shoot him if he didn't stop running from the police. They were able to take him into custody, certainly without him continuing to assault and obstruct them first. Then, while they were inventorying the car that he fled in, they recovered a magazine from a handgun. This is a convicted felon, multiple times over. They knew, based on their experience, that typically where there's a magazine, there is a handgun. And they discovered a handgun on the route and he fled from them.
This detail significantly escalates the seriousness of the case. Police allegedly recovered a firearm magazine inside the vehicle and later located a handgun nearby. For most individuals, that might raise legal concerns, but for a convicted felon, possession of a firearm becomes an entirely separate felony offense. In many jurisdictions, felon in possession charges carry severe penalties because the law strictly prohibits individuals with certain criminal histories from owning or possessing firearms. The prosecutor also explains that officers suspected the defendant was under the influence and are awaiting blood test results. If those results confirm intoxication, additional charges could follow. So the allegations now include reckless driving, fleeing police, possible intoxication, and illegal firearm possession. Each additional factor increases both the legal consequences and the prosecution's argument for stricter bond conditions. At this point, the judge must evaluate not only the past record, but also the potential risk to the public.
In addition to that, however, they also found, suspected, that he was under the influence. So we are waiting for his blood results. Refused any testing. The blood testing is still in the lab. And then, as you can see from your charges as well, he was in possession. He was in possession of a baggie that had some type of white powder in it. This was something he left behind in the deputy's vehicle. Your Honor, I'm requesting either just straight revocation, bond denial, or this bond violation of failing to ever go to community corrections, or I'm requesting the 100,000, which was already the request in this case. Thank you.
Mr. Jervis.
Your Honor, he was arraigned on February 12th. He did post his cash or surety on the 18th of February. Had a PCC on 2/22. Everybody was in court the last hearing. That was not addressed regarding his testing. He obviously got out. He didn't go to community corrections. He was unaware at that time. No one reminded him on the 22nd. I got the bond violation yesterday at about 4:10. I called him and told him to go to community corrections immediately. Got back on the phone with him, told him they closed at 4:30 to show up at 8 in the morning. He was there 8 in the morning to try and do an intake. They would not take a test, or they would not do an intake this morning. He was told due to the bond violation. His mother is here with him today. He's obviously showing up to court. He's not driving. He was in his mother's car. As far as, minimally, I don't know the full facts of the case. I did start reviewing some of the video. I do understand that there may be another occupant to that vehicle. I'm not too sure on who the actual driver was of that vehicle, be with 2 occupants. So regarding, I'm asking that the bond remain. I'm asking that he report to community corrections today, allow him to do the intake, and continue on a testing.
Why didn't he go test?
I don't know. And the other thing is, no one reminded him the last time that was in hearing.
Okay, but he was told at arraignment to go test.
I understand. He was in custody at the arraignment and didn't post until 40 or 6 days later. So when he got out 6 days later, he didn't go and test. That is correct. And then he showed up 4 days later to his last hearing that got adjourned until today.
In regard to we don't know if he's the driver, he is being pursued by the police straight out of the driver's seat. They watch him get out to seat and they pursue him and they arrest him. So there's no break in that pursuit.
This statement from the prosecutor is extremely important because it directly addresses a defense argument that had just been raised moments earlier. The suggestion that there may have been another occupant in the vehicle and uncertainty about who was actually driving. In criminal cases involving police pursuits, establishing the identity of the driver is critical. If the defense can introduce reasonable doubt about who was behind the wheel, it can weaken several charges, including fleeing and eluding law enforcement. But the prosecutor is clearly trying to shut that door. By emphasizing that officers watched the defendant exit the driver's seat and immediately pursued him without interruption, the prosecution is reinforcing the idea that there was continuous observation. In legal terms, this is often described as an unbroken chain of identification. If the judge accepts that narrative, the defense argument about another driver becomes much harder to sustain. You can see the strategy unfolding here. Prosecutors often focus on these small factual details because they strengthen the reliability of the police account. And when judges evaluate bond decisions, the strength of the evidence can matter just as much as the charges themselves. So the question becomes, does the judge believe the evidence against the defendant is strong enough to justify stricter conditions or a higher bond?
I emailed community corrections yesterday asking for a community corrections update on him. Basically, I was looking for more fuel for this fire of this argument. They forwarded me that bond violation. I did not have a copy of it. It looks like the court didn't have a copy of it last time we were here.
We were here on what day?
The 22nd.
Something tells me that it was dated the 21st. I don't know what time it came It actually is in my file, but I'm not sure when it came down because it doesn't appear that it was here the last time that we were here. When was he released from prison?
13.
2013.
2015, his parole is now expired.
Pardon?
His parole's expired.
Send him over there right now. Is he going to test clean?
The answer to that is questionable, but it will probably come back.
Questionable.
Well, I do have the belief that he at least used marijuana prior to the last few days.
And the defendant's bond is increased to $50,000 cash surety.
Judge Simpson delivers his ruling, and it reflects a calculated middle ground decision. Instead of revoking bond completely, the judge increases the bond by $50,000 cash surety. That type of bond requires actual money to be posted to secure release. Unlike personal recognizance bonds, which rely primarily on a promise to appear, cash surety bonds create a significant financial stake for the defendant and anyone assisting with the bond. Judges often increase bond amounts when they believe a defendant presents a higher risk, either a risk of fleeing the jurisdiction or a risk of committing additional offenses while awaiting trial. In this situation, the judge likely weighed several factors: the defendant's criminal history, the seriousness of the allegations, and the potential danger posed by the police pursuit described by the prosecutor. But he also chose not to revoke bond entirely. That suggests the court believes supervision with financial pressure may still be sufficient to ensure compliance. Bond decisions like this are rarely simple. Judges must balance the principle that defendants are presumed innocent with the responsibility to protect public safety. And that balancing act becomes even more difficult when the defendant has a long record of prior offenses.
Defendant's removed. Court calls case People versus James Hall. I haven't signed this order on this matter. Your name, sir?
James Hall.
You were represented by Miss Hughes. Was she in contact with you, sir?
Miss Hughes. This lady?
No.
Oh, the other lady? No.
Have you spoken with an attorney at all?
Yeah, this lady yesterday.
Okay. All right. All right. That was a bad question on my part. Prior to speaking, sir, had you met with an attorney before now?
I don't remember.
When did I? Hold on a second. Was Miss Rushing on this case, or?
Initially, it was the first appointed, well, after the public defender's office.
And then Miss Hughes was appointed.
Your last time with us.
All right. I directed her to appear, but Ms. Hughes apparently doesn't believe that she has to. She's already subject to a show cause in another matter because she hasn't dealt with her clients directly before leaving. So we will deal with that. I will sign this order, however.
Thank you, Your Honor. For the record.
I'm not mad at you. Don't worry about it.
Okay, Your Honor. Good morning. For the record, Rita Young, P44626, appearing on behalf of Mr. James Walter Hall, who is present and standing to my right. Sir, would you state your name for the record?
James Walter Hall.
Your Honor, today is a date and time set for a probable cause conference. We'd like to waive, and we've executed the waiver for.
All right. You want to waive your right to a preliminary examination, sir?
Yes, sir.
Here we see a procedural move that happens far more often than many viewers realize. The defense chooses to waive the preliminary examination. At first glance, giving up a hearing might seem like surrendering an opportunity to challenge the prosecution's evidence, but in practice, this can actually be a strategic decision. A preliminary examination requires the prosecution to present witnesses and evidence to establish probable cause. If the defense believes the prosecution already has enough evidence to meet that standard, contesting the hearing may simply reveal more of the defense strategy without changing the outcome. By waiving the examination, the case moves forward more quickly to circuit court, where more serious negotiations, motions, and potentially a trial will occur. Now, you'll notice the judge carefully asking the defendant if he understands what rights he is giving up. That's required by law. Courts must confirm that a defendant knowingly and voluntarily waives important procedural rights. Once the waiver is accepted, the case is officially bound over to circuit court. That means the stakes just increased significantly for the defendant.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yeah, I'm not. Wait.
I know, but I got to make sure you understand what you're waiving.
I understand.
Okay, then just answer my questions.
Yes, sir.
You understand you won't have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
Okay. People also waive their right?
Yes, Your Honor, thank you.
Yeah. Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
As to the arraignment on the information, I waive a formal reading, Your Honor. We stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
4th at 1:30 before Judge Slade Thursday.
April 4th, 2024, 1:30.
With the preliminary examination waived and the case bound over to circuit court, the judge now schedules the next major milestone, the pretrial conference. Pretrial hearings are where many criminal cases are quietly resolved. Attorneys review evidence, negotiate plea agreements, and sometimes file legal motions that could shape the outcome of the case. For example, the defense might challenge the legality of a search, question the reliability of certain evidence, or argue that police procedures violated the defendant's rights. Prosecutors, on the other hand, evaluate whether the evidence is strong enough to justify proceeding to trial. It is not unusual for cases to resolve during this phase through negotiated plea agreements. Trials are time-consuming and unpredictable. So both sides often weigh the risks carefully before deciding whether to continue fighting the case in court. So while the judge simply sets a date here, what's really happening is preparation for the next stage of legal maneuvering.
Judge,
Slay Thursday.
Oh, sorry.
And tell him to say, yeah, whatever to slay.
Judge, may I briefly respond?
I want to see that. Go ahead, yeah.
Thank you. My client is 47 years old. He resides at the address that's on file. His bond is currently set at $10,000 cash surety bond. There was some confusion regarding court dates. That will never happen again, Your Honor. I will frequently remind him of his next court dates. He reports that he's served in the U.S. Air Force for 16 years. He has no prior felony conviction. And so we would ask the court to please consider a personal recognizance bond. He has no objections to home confinement if the court deems that necessary.
Any response from the people?
Yes, Your Honor. I was within the court's discretion. However, the reason that he is in custody is because he failed to appear on December 7th. At the time that he failed to appear on December 7th, he already had a community corrections violation report, which is more so what my concern is how do we know he's going to go to community corrections? This is the case he does. But right now, we did not request a bond on this case. So the $10,000 is what we requested at charging. If there could be some assurances that he's going to community corrections, that would certainly make me feel more comfortable.
Mr.
Yeah.
Paul, you have to go to
I-
community corrections. You'll do that?
I can do that. I have caseworkers that could get me there every week or every day.
Caseworkers from where?
Avalon
Housing.
Housing, and I have CMH. as
Are
well.
they, okay, but how are you gonna pay for your testing?
I have Social Security.
Gonna need an order. I'll set the defendant's bond at a $10,000 personal recognizance bond. I'll release him. I'll put him on standard supervision with a urine test once per week.
This decision marks a dramatic shift in the courtroom. The judge grants the defendant a personal recognizance bond, which means the defendant can be released without paying a large amount of money up front. Instead, the defendant promises to appear in court and comply with supervision conditions. This type of bond is often granted when the court believes the defendant does not pose a serious flight risk or danger to the community. Several factors appear to influence the judge here. The defense mentions that the defendant served 16 years in the United States Air Force, which suggests a long history of discipline and service. The attorney also emphasizes that the defendant has no prior felony convictions, which significantly changes the risk assessment compared to earlier cases discussed in this hearing. And judges frequently consider a defendant's background, community ties, employment history, and military service when determining bond. However, the release is not unconditional. The defendant will still be under weekly supervision and testing, meaning the court will continue monitoring compliance. So the judge is essentially offering the defendant a chance to demonstrate responsibility moving forward.
Yeah.
Thank you. Thank you so very much, Your Honor.
I'm good.
Yeah.
Yeah.
Oh, Mr. Paul, need your signature here, please.
Sorry about that.
Right here.
We're gonna have to go get him. Court case of the people versus Barrage Scott.
Scott, Mr. Scott, please state your name for the record.
What are we doing?
Thank you, Judge. We were here a couple weeks ago on these two cases. Mr. Scott has a bond violation, which is why he is back incarcerated for allegedly going to a no-go-to area on conditions. Obviously, I met with him in jail. He understands he's put himself in another bad position. He doesn't have a great excuse for it. He doesn't have a great excuse for it. He acknowledges that he messed up in this matter. He's asking the court to let him out again.
To do what?
To let him out again. He is saying that he has applied for Social Security, and if he is not out, he will lose his ability to get that Social Security as well as his disability. And he has a healthcare situation where he needs to get a shot that his insurance has to pay for, that he won't be able to go out and get if he's incarcerated, Your Honor. So he's asking me to consider releasing him back on a personal bond. But what I'm hoping to have done with the case, Your Honor, is just to adjourn the PCC for a couple of weeks so that we can see if we get something resolved on it.
No objection to the adjournment. Probable cause conference, March 28th, 2024, 9 a.m. People's position on bond.
Misunderstanding. But his violation is not just going back to the area he was ordered to not go back to. It's that he gets there, he decides to assault 4 police officers. That's the violation.
Now the courtroom atmosphere becomes far more intense. The prosecutor describes an alleged bond violation that goes beyond simply visiting a restricted location. According to the prosecution, the defendant returned to a prohibited area and then assaulted multiple police officers. That type of allegation dramatically changes how the court evaluates the situation. Bond violations are serious on their own, but when new alleged criminal conduct occurs while someone is already under court supervision, judges often view it as evidence that the individual cannot follow court orders. The prosecutor is clearly emphasizing a pattern here, returning to a location where the defendant was explicitly told not to go, committing additional offenses, and creating another confrontation with law enforcement. From the prosecution's perspective, this demonstrates a repeated disregard for court instructions. When prosecutors frame violations in this way, they are essentially arguing that continued release would pose an unacceptable risk to the community. And now, the judge must decide whether this latest incident crosses the line where additional chances are no longer appropriate.
So he was arraigned, I apologize, we'll get these things to you. He was arraigned on February 13th on an RNO and a trespass from Village Grove. He was told not to commit any additional crimes, no assaultive behavior, and no go-to. So he goes back to Village Grove, he commits more crimes, he assaults more police officers, and he goes to where he's not supposed to go.
No, look at me, bro.
You're telling me that's wrong. But
No.
So now we're here on these 2 cases. In addition to that, so Mr. Easter's done a fantastic job working this file as well as he does all his files. He has tried to negotiate.
Except the dog way. Wait, go ahead.
He has tried to negotiate this case with me. I've explained to him that I do not intend to make Mr. Monte Scott any offers. He just finished a jail sentence in the fall for RNO.
I know.
This is a person that was sentenced to Washington County Jail for RNO, gets out, it's 2 new RNO cases. Your Honor, his bond actually is low, but I wasn't the one making the request. $5,000 is low for what he's done, but I'm asking Your Honor not to grant the PR bond to the bond as is if you're not inclined to increase it.
Only thing I'll say, Judge, is that Mr. Scott was under the impression that his violation was for the trespass. Now he's heard Ms. Hughes' understanding about the RNO.
He does this every time.
Yes, Judge.
Yeah, no, what are you gonna say?
I'm sorry.
Okay.
Get in no more trouble. I just did.
Mr. Scott, every time you come here, you plead with me, let me out. I usually say no. Then finally I let you out. And what do? You go right. This is not, I realize that you've not been convicted of anything, but I will say this. This is not the first time that you've been someplace, something happens, you're not supposed to go back.
This exchange reveals something that happens frequently in busy criminal courts, judges dealing with defendants who appear repeatedly before them. Judge Simpson's frustration is clearly rooted in history. According to his comments, this is not the first time Mr. Scott has asked for another opportunity to remain free. Judges often develop long memories of cases like this. When the same individual repeatedly returns with new violations or new charges, the court's patience naturally begins to wear thin. From the judge's perspective, the pattern becomes the most important factor. Promises made in court carry less weight when past promises have not been kept. Meanwhile, Mr. Scott pleads for another chance, mentioning family birthdays, health concerns, and a desire to start fresh. These emotional appeals are not uncommon in courtrooms. Defendants often try to demonstrate personal motivation to change, but judges must decide whether those statements reflect genuine change, or whether they are simply part of a cycle that has played out many times before.
Tell you not to go back, and what happens? You go back, and you either come back before me on a bond violation, or you come back with a new case because of what you did when you got there. And by the way, other problem that happens is that when you go back to these places, naturally, the police get called. And then you start having issues with them. And
I won't have no issues. I promise you, look, I promise this time, because I just did a year, I won't have no issues if you let me out. I'll do the right thing and I won't go back. Just one chance, because
One chance?
I mean, just
One more.
one more chance, please, Your Honor. And I promise I won't go back. Just give me this chance and I'll do everything right. I'm trying to start fresh. Fresh. I just want one chance from you. And
You know what, Mr. Scott?
one more chance.
No. And today, I'm going to tell you no.
Please, Your Honor. Please, because my grandma's birthday is on the 24th and I really want to.
I know. And
I don't want to be in jail. I can't. I will do just give me this chance. I promise you, if I go back, I deserve to be locked up, but I won't go back. I won't go back. I won't go back.
Mr. Scott?
I just want one chance, please.
Mr. Scott?
I want to be in jail.
I know you don't want to be in jail, but you got to listen to what we're telling you.
Okay.
You remember I even put you on a tether.
I
know, but that didn't work either.
I'll do that.
Mr. Scott.
I'll do whatever you want me to do, and I promise you, this time I won't mess up. I won't mess up, Your Honor. Please, just trust in me.
You want me to go get the last 3 recordings when you told me that?
No.
No, because you told me the same thing.
No, but I'm telling you the truth. If I deserve a chance, this time, because I just did a year. Just give me a chance for this time, and I will do everything right. I won't go back to Village Grove. I won't catch nothing. And I promise you, this time it's gonna be the last time I ask. It's a new year.
Oh, last time this year.
No, the last time I asked for anything. And if I don't follow your rules, I deserve to be locked up. I just want a chance to be back in the community, be with my family. Because if it's gonna be hard, my Social Security been cut off for a whole year. I haven't even got my check yet and then I gotta get my shot on Monday. If I don't, they can't give me my shot in here because it's a $10,000 shot. But I do need my shots. I have to go to CMH. I'm starting my new job next week at the CMH building. Just give me this chance so I can do all this stuff. And if I promise you, this will be the last time I promise you anything.
Is this Groundhog Day? Because this is the same thing I hear.
But I'm telling you.
How many times have you told me this?
All right.
This is like the 4th time.
Let's make a deal.
Oh, wow. Okay, so we're gonna start negotiating.
Yeah, we're gonna.
Okay.
All right. So if
you realize this isn't a fair negotiation,
because you're the judge and I'm not.
Yeah.
Yes.
Yeah. Okay. As long as we understand that, go ahead.
All right. This would be a bigger deal. If I get any more trouble, you can lock me up for a whole another year. I just don't want to get in no more trouble.
At this moment, the defendant attempts to negotiate directly with the judge. He essentially proposes a personal agreement. Give him another chance, and if he violates the rules again, he will accept severe consequences. While this might sound persuasive emotionally, courts rarely make decisions based on informal negotiations like this. Judges must rely on legal standards, documented history, and the credibility of the defendant's past behavior. Judge Simpson even jokes briefly about the situation sounding like a negotiation, acknowledging that the power balance in a courtroom is not equal. The judge ultimately reminds the defendant that similar promises have been made before. This moment highlights a difficult reality within the justice system. Courts must balance compassion with accountability. Giving someone another opportunity may help them rebuild their life, but repeated violations can undermine the court's authority and put others at risk. And Judge Simpson appears to be weighing that balance very carefully.
Mr. Scott.
I don't want to get, listen, I don't want to get in no more trouble, Your Honor.
I know you don't want to. You can't help it.
I can't help it, but I do need my shot. And if I don't get my shot, I can go to the mental hospital or anything. I don't want to.
Well,
can you give me
Washington County Sheriff's Office will make
this is the last chance I have. No, they can't. It's $10,000. They can't pay for it because my insurance can't. My insurance can pay for it on the outs. And I'm getting my job back. Please let me go back home. I don't care if you put me on tether. I don't care if you put me on house confinement. I will do the right thing from now on. I won't get in
both of those we tried.
Can we
they
try
didn't
one more
work.
time?
No, not today.
Well, can we try to let me out this time and then
not today?
But Mr. Simpson, If you don't let me out, I won't be able to shoot. I won't be able to show you I won't be able to show you my honest thing, man. Just, Mr. Simpson, please just give me one
Mr.
chance.
Scott,
I don't want to be locked up.
Mr. Scott, I know you
I
don't.
don't want to be locked up, man. Every
But-
time
but
I get
Mr.
locked up, somebody put their hands on me or do something to me in there.
Okay, Mr. Scott.
Yes,
listen to
sir.
me. We go through this every time.
But it's a new year.
And what?
It's a new year. Just
Listen to him.
I'm gonna listen to him. I'm just getting emotional. I'm sad right now.
I know. And all I'm going to tell you is, I won't say it won't happen ever, but not today.
Well, what am I supposed to do? I
Just
can't.
sit tight. Just sit tight.
If you give me this chance, Your Honor, I promise you, listen, I promise you, I'll do the right thing.
Say no.
I'll do the right thing from now on. Just one chance, Your Honor. You saying no, but in your heart, I know you really wanna give me a chance in your heart. Just give me a chance this time. I
I
promise.
appreciate you acknowledging that I have a heart.
I know you got a heart, but can you please just, Simpson, please just give me a chance this one time.
Okay. You can go to.
No,
Well, can I have a lower bond?
not today, Mr. Scott.
Well, my grandma's birthday is on the 24th.
Today.
My brother's birthday on the 23rd. My sister's birthday on the 22nd.
You can go to deputies.
What am I supposed to do? I mean, I don't want to just sit in jail and rot.
You gotta sit tight, Mr. Scott. He close to
My
file.
intention is not to have you rot in jail, but I'm not letting you out today.
So I'm not getting out no more.
Go to deputies.
Not today,
So when do I come back to court?
the 28th.
And then what?
We'll try.
I don't know.
You say that all the time. You don't know.
Whoa,
No,
really?
I'm not saying you.
Seriously?
No, I'm not
I think
like
you
that.
need to stop about now.
No, I'm saying like.
I think you need, Mr. Scott, you need to stop about now.
I'm sorry. I apologize. I don't want you. I mean, I don't want you to say that all the time. That's what I meant.
Okay,
That's what I meant.
I know.
But what? Well,
Okay, all right. Go to deputies.
am I gonna get out ever? That's all.
Oh, eventually, yeah. Because we'll run out of time.
Huh?
Nothing.
Go.
All right, thank you.
All right. Gotta go now. Gotta go now. No, because every time you get wrong. Let's go to deputies.
I wish.
All right.
We'll see what happens on 28. You're in
How
custody.
you doing?
Good to tell you.
Okay, then you're in custody, and then just be
Good to tell you.
alone.
Oh,
Yeah.
so, got it.
It's all your property.
I didn't want to let you know.
Court recalls, okay. Garage, cooperate, don't mess up, because you do something here, then we're gonna have a problem. Okay. Why seriously? I don't know why you let that happen, Feaster. Court calls the case.
This hearing illustrates just how complex and unpredictable courtroom decision-making can be. Across several cases, Judge Simpson faced a wide range of circumstances, from bond violations and criminal history concerns to requests for release and emotional pleas for another chance. In some situations, the court allowed defendants to remain free under stricter supervision. In others, the judge increased bond amounts or refused release entirely. Perhaps the most striking moment came during the exchange with Mr. Scott. Despite repeated promises and heartfelt appeals, the judge ultimately declined to release him that day, citing a pattern of violations and broken commitments. Moments like these highlight the difficult role judges play. They must weigh the presumption of innocence, the credibility of defendants, the arguments of attorneys, work in the safety of the community, all while making decisions that can dramatically affect someone's life. Courtrooms are not simply places of punishment. They are places where responsibility, accountability, and second chances intersect. But every second chance carries risk, and every decision must balance fairness with protection of the public. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.